project because we all know that it has a very long and storied history of helping to engender transitional justice and supporting those projects all over the country. And of course, we're definitely gonna hear about that, I'm sure, from Kelli Muddel later on in the panel. But in addition to that, I think you're also right that, part of what motivates this project and what motivates much of our work is that we do live in environments where some people are considered less, right? And LGBT people in Colombia, they're either not part of historical accounts or predominant narratives about the armed conflict, or if they are part, they're seen as lesser than, or the violence is seen as not serious, right? And so one of the even legal obstacles that we faced throughout this process was trying to convince other people, other lawyers, the Special Jurisdiction for Peace, that this violence was even serious enough to merit an investigation, right? And now we get to say it's so serious, in fact, that it's a crime against humanity. And that crime against humanity is persecution. And you need to investigate it, and you need to look into it, and you need to punish these forms of violence, and work within the sort of mixed scheme that the Special Jurisdiction has adopted to communicate the message that to the broader society that these violences have been an integral part of the Colombian conflict, and that we cannot leave these victims, leave them aside. So I really appreciate all of that. Thank you very much. And we really do hope that it results in a breakthrough, not just here, but hopefully in other parts around the world. And it will be in English, so it will be of access to Spanish speakers and English speakers. So thank you. Now we are going to move on to our next speaker, which is Victor Madrigal-Borloz. He is the UN independent expert on protection against violence and discrimination based on sexual orientation and gender identity. In this capacity, he assesses the implementation of international human rights law, raises awareness, engages in dialogue with relevant stakeholders, and provides advisory services, technical assistance, and capacity building to help address SOGI-based violence and discrimination. Mr. Madrigal-Borloz is a Costa Rican jurist and a senior visiting researcher at Harvard Law School's Human Rights Program. Until June 2019, he served as the Secretary General of the International Rehabilitation Council for Torture Victims, a global network of 150 rehabilitation centers with the vision of full enjoyment of the right to rehabilitation for all victims of torture and ill treatment. As a member of the UN Subcommittee on the Prevention of Torture from 2013 to 2016, he was also rapporteur on reprisals and oversaw a draft policy on the torture and ill treatment of LGBTI persons. Prior to this, he led technical work on numerous cases, reports, and testimonies as head of litigation and head of the registry at the Inter-American Commission on Human Rights, and worked at the Danish Institute for Human Rights in Copenhagen and the Inter-American Court of Human Rights in San Jose, Costa Rica. He is a founding member of the Costa Rican Association of International Law, a founding board member of the International Justice Resource Center, and a founding board member of Sinergia IDH. Well, now, thank you for being here. Mr. Madrigal-Borloz, you have the floor.
Thank you very much, Lucia. It's a great honor to be here amongst this very distinguished group of panelists, and I'm delighted by the anticipation of everything that I'm about to learn from this great group, and also what we've already heard from Myriam Roccatello. Thanks to Colombia Diversa, your work is always such significance of excellence. It's always for me a delight to work with you, and to the International Center for Transitional Justice, also a point of reference. So it's a great delight to be here. I'm very thankful for the issuance of this study in my position as independent expert. And the reason for that is that, as many of you know, the mandate that I have is, on one hand, to create visibility of the way in which violence and discrimination manifests itself in the lived experience of lesbian, gay, bisexual, trans, gender diverse persons. And on the basis of also an understanding of those lived experiences, to actually advise states on what may be effective measures on the work of addressing, systematizing, analyzing, and ultimately eradicating those manifestations of violence and discrimination. And in that endeavor, there are areas that have been more explored and where evidence is more, exists in a more abundance within the international spheres. And there are areas that are significantly very opaque. And I think the area of armed conflict is one of those, where we haven't even begun to scratch the surface of an understanding of the ways in which violence manifests itself during situations of armed conflict. So I am exceedingly thankful to you for having embarked in this investigation, because in a way you have helped my work a lot, and you have saved me probably a lot of research that I would have needed to do myself if you hadn't done it. So I'm really delighted and of course very much eager to use the findings in this book in the furtherance of the work of the mandate. Interestingly enough, this book comes at a moment where this topic is going to be at the crux of a number of rather significant initiatives in international human rights law. So the most recent report by the Special Rapporteur on Right to Truth is going to be on situations of transitional justice and gender. And I think that there's going to be a significant point of intersection between your findings and the findings of our dear friend Fabian Salvioli in relation to these issues and the meaning that is given. And I'm sure that the Colombian case will be very much at a crux in relation to these issues. Now, it is also quite fundamental because as we all know, we are at a moment in which in the political sphere, in political discussions, there is significant political debate as to whether gender can exist in the language of international human rights law as an autonomous concept, or whether, as some are propelling and spending significant political capital, it needs to be equated strictly with the category of sex, as some seem to read the definition of the Rome Statute. And I say some because it's very clear to me that you don't read it that way, and yet I believe that others will make the point that the language of referring to the two sexes, male and female, was put there because of a particular reference to the binary, to which I think Mr. Roccatello has already made mention in relation to this. So we are at a point in which the production of this evidence is fundamental to understand what is the contribution, the conceptual and pragmatic contribution to processes of justice and reparations of gender-based approaches, and gender-based approaches that go into that area that, of course, is not the area of binary sex understood from the point of view of genitalia only. And this is why I think this study takes a point of departure and a point of arrival in a way that is actually quite an extraordinary contribution to these issues. Now, the reason for all of that is, of course, my mandate has the theory, which I think has been sufficiently explored in a number of the reports that I have had now the honor to issue, which is that at the root of violence and discrimination based on sexual orientation and gender identity lies the defense of a particular system of power relations. A particular system of power relations in which there is, of course, a nefarious asymmetry between the female and the male, and all of the consequences of what is seen as female and male within a context of point of reference in the binary. And it's a system that relies on the creation of a notion of otherness, or in Spanish, alteridad. The idea that through mechanisms of pathologization, demonization, or criminalization, there would be the notion inserted deeply into carving deep grooves into social awareness that LGBT people are in and of themselves, because of their very existence, somehow antisocial or disordered or pathological, and therefore inferior in a notion where either that inferiority needs to be cured or repressed or ultimately punished. And I think, of course, that this is where our work meets at very significant points in relation to their practical implementation. Now, I would also like to make very quick reference to a process which went on last year. I'm sure that many of you are aware of it, which is, of course, the process of preparation of the draft Crimes Against Humanity Convention, where, as I'm sure you're aware, there was a moment in which the Commission was very much considering a point of reference in definitions based on the Rome Statute. And there was a concerted action by a number of my colleagues and I to present to the International Law Commission a body of evidence in relation to the concept of gender and why the reproduction, the automatic reproduction of the definition under the Rome Statute would be quite ill-advised in our opinion. And that is, of course, the development under international law that recognizes that deep connection between a gender norm, which might be considerable as the desirable norm within a given society, and the notions of punishment, repression, cures for all of those that actually vary or depart from that notion, in which I actually have presented substantial evidence about in my reports. And what we very much were hoping that the International Law Commission would do in very practical ways would be, on the one hand, to basically remove the definition of gender, taking that took point of departure in the Rome Statute, and also to include in the grounds for persecution autonomous grounds that we believed had been sufficiently explored in international law from 1990 onwards, and that included sexual orientation, gender identity, language, social origin, refugee and migratory status, and so on and so forth. And this submission was, I believe, quite well fundamented, and it included one specific point to the fact that even implicitly issues of sexual characteristics are not included necessarily under the concept of sex or gender. Now, as time would have it, we are now in a position where we know that the International Law Commission actually did not take as point of departure the definition in the Rome Statute, and that in its reasoning, in the commentary issued at its 71st session, it actually cited the developments, the 2004 guidance of the International Committee of the Red Cross, the 2010 Committee on Elimination of Discrimination Against Women General Recommendation, and a plethora of other elements, and also the definitions and the concepts that have been coined by special procedures, including the mandate that I have the honor of actually taking as justification for departing from that definition, which under Resolution 74-186, the General Assembly will now take forward under consideration. Now, my delight when reading your study, and with this I finish, is that even within the limitations that we have signaled, and which created significant worry in our understanding, you are exploring a parallel understanding of how persecution lies at the origin of full applicability of these dispositions to sexual orientation and gender identity. And I think that it is a persuasive body of interpretation, what you've created throughout this study, one that actually I think will be very useful for an understanding. As we all know, quite unfortunately, prosecutors have brought charges of various forms of sexual violence. The International Criminal Court has never successfully prosecuted, these charges to an extent where one could actually extract a body of jurisprudence that takes this forward. But I actually think that this will be part of what we see in the future, and to which your study actually takes us a very long way. Lucia, Daniela, again, and to the colleagues in Colombia Diversa, I'm delighted to have been part of the group that has been reading this study. I thank you very warmly for it, and look forward to learning from the other colleagues in the panel. Thank you very much.
Thank you so much, Victor, for those very, very kind words. we're very grateful to hear that from you. And I actually just want to come back to a couple of your points. The first one being, which is something that Ms. Roccatello mentioned as well, the importance of breaking that gender binary in international criminal law, but also in other spaces that are related to peace building and gender, for example, the Women, Peace and Security resolutions, right? And to try to broaden the scope and get the Security Council, for example, to recognize that women are not a homogenous group, and that many forms of gender-based violence are exacerbated during armed conflict. And I'm sure, Daniela and the panelists will go into further detail about this, but we do firmly believe that LGBT people fit in the sort of definition of gender in the Rome Statute. Not only because on a conceptual level, if you're forcing people into narrow gender roles that are based on a sex binary, then how can that not fit into that definition, right? And that's exactly what happens to LGBT people, right? Sexuality, compulsory heterosexuality is is an integral part of our gender roles. And if you're not going to punish, for example, a person with a penis for being attracted to a woman, but you're punishing a man, a person with a penis, for being attracted to another man, then of course that fits. And so that on one hand, but also that we've seen in international human rights law, and in specifically for the case of Colombia, in Colombian constitutional case law, SOGI, sexual orientation and gender identity are protected classes. And so how can that not once again fit under the definition of gender in the Rome Statute? So that on one hand. And on the other hand, I do agree with you, and I think all of us at Colombia Diversa agree with you, that armed conflict has been particularly opaque when it comes to LGBT people, and that we're just starting to scratch the surface. In fact, part of the challenge with this research and what we had to do is that we were sort of starting from scratch, and that in international law, there isn't much anything on LGBT people and armed conflict. And if you look at the literature, there also isn't a huge literature on LGBT people and armed conflict. And so we actually drew a lot on the literature on violence against women, gender-based violence, sexual violence. For example, we drew a lot on Elizabeth Wood's articles on sexual violence. And that, which has been, there's sort of there's a very rich intellectual production around those forms of violence that has helped us understand how violence operates against LGBT people in the armed conflict. But because LGBT specific knowledge is still under construction, both in the legal sphere and outside of it, we're still figuring out a lot of things. What we do know for sure, which is also something you touched on, is that there is a system behind this violence, and that there are commonalities, and that it feeds off each other, of both how the violence works in armed conflict and outside of armed conflict. Those same stereotypes of LGBT people as sick or as inferior that sort of lead to these conversion tortures are some of the same stereotypes that armed actors capitalize on during the war for their own gain, right? And that's something that is still difficult for people to recognize, right? That these things, it doesn't just happen as a byproduct because of that system, but rather that it is integrated into the system of war, so to speak. And all of this also, like you said, comes at a very important moment for international law and history, not only because of the report from the Transitional Justice Rapporteur, who we do hope, we actually did send some information to him, so we do hope to see some of our ideas reflected in his report and some of the developments in Colombia reflected in his report, but also because it's the 20th anniversary of the WPS resolutions. And we have been working to sort of expand that arena as well, and to make sure that there's a voice for LGBT people in that arena as well. So we do hope these ideas that they also transcend to those spheres. So again, thank you so much for your very kind remarks, and we are very much in agreement on your analysis. So I think now we're going to move on to our panel. For this panel, we are excited to introduce two experts on gender and transitional justice who have dedicated their careers to addressing the gendered impacts of conflict and advancing feminist perspectives in transitional justice. After each of the panelists present their remarks on the orders of prejudice, we will open up for discussion with the author and for questions and answers from the audience. So to kick off the panel, first I'd like to introduce our first expert, Dr. Catherine O'Rourke. Dr. O'Rourke is director of the Transitional Justice Institute and senior lecturer in human rights law and international law in the School of Law at Ulster University. She researches, teaches, and engages in policy work in the fields of gender, conflict, transitional justice, and international law. Her PhD from Ulster University Transitional Justice Institute was subsequently published as a monograph, Gender Politics and Transitional Justice, in 2013. Her new monograph, Women's Rights in Armed Conflict Under International Law, is published with Cambridge University Press in 2020. Both books include Colombia as a case study. She also works with the Irish and UK governments, the United Nations, and several non-governmental organizations in policy work related to her expertise. She is regularly commissioned by intergovernmental and non-governmental organizations to conduct expert research, such as UN Women and the Office of the High Commission on Human Rights, and the International Criminal Court Trust Fund for Victims. She's a member of the Gender Legacy Integration Group, which is a feminist network of civil society and academic actors working to promote gender principles for dealing with the legacy of the past in Northern Ireland. We are very grateful to have her here and very excited to hear her comments. But before I give Dr. O'Rourke the floor, I do want to thank the 28 participants that are here listening to us and that are participating in this event and in this discussion. We expected it to be sort of a tight-knit group, and we're happy to see that so many people were interested in hearing about this event and these perspectives. So shout out to all of you. And now, Dr. O'Rourke, happy to hear from you.
Thank you for the invitation to join you. I'm joining you this morning from St. Paul, Minnesota. I just got here last night from Belfast. So I may say here quite a bit, and actually I'm thinking Belfast. But so I want to commence just with my warm congratulations to the author and to Colombian Diversa for an essential and genuinely unique initiative to surface and bring a robust kind of legal framework and an empirical evidence base to many of the things I think that we've been mulling, many of the challenges that those of us in the field have been mulling over for really some years now. And I mean, the significance of the book is multi-level. I thought I might start a little bit just on context. So what struck me most is the book responds to two exclusions that those of us who work in the fields encounter routinely. The first exclusion, I mean, is this sort of ongoing challenge around deepening a notion of gender in our transitional justice work. And and in some sense, I mean, my work for a long time has focused more specifically on the question of women's inclusion. And that has been an uphill battle for quite a long time. And indeed, just reflecting on the UN Global Study on Women, Peace and Security that was published in 2015. I mean, its findings around transitional justice were particularly negative in terms of overall kind of national level and international level policy and practice on gender and peace building. So there is a very exclusionary context that I think we need to acknowledge more broadly in terms of the international framework. And then I think more locally, I know that we've been encountering this in Belfast, where, as in the introduction mentioned, I'm part of a network working to embed gender within our kind of quite fraught process to deal with the past. And that even doing that work as a feminist, we are constantly aware of the exclusions of the way that we do our work, actually, because operationalizing a notion of gender, a more complex and deeper notion, is really quite hard. Particularly when you are still making, foundational level arguments about actually it's really not okay that these decisions are being made exclusively by men, particularly in institutions that will probably deal more with women, right? So that has really, so I know certainly locally we have really started to reflect more on the exclusions of our own work, actually, as feminists making a feminist intervention into transitional justice in terms of who have we silenced and left out, and what are the stories that we have failed to surface. And in attempting to do our own work better, Colombia has actually always been really quite inspiring for us. We have looked pretty consistently, certainly it seems to me, in terms of even at the most important rudimentary kind of intervention around actually documenting gendered harm against sexual and gender minorities, ensuring that some of that story is captured in transitional justice processes. That civil society work in Colombia has absolutely led the way and has shown us how it can be done elsewhere. So even in my PhD work looked at the justice and peace process, obviously a very difficult process, but even the insistence on civil society at that point to surface gendered harms against sexual minorities was really quite inspiring and absolutely led the field, I mean, in an international space. So I want to sort of tip my hat to Colombia Diversa and your colleagues in Colombia for the work that you're doing, because you are absolutely an inspiration to us who are trying to do this work elsewhere and do it better. And you've absolutely shown the way and called us, I think, to challenge, to rethink how we are doing our own work. The other then sort of exclusionary piece that we're dealing with here, and this has already been alluded to by Victor, is the issues around the Rome Statute and the not just the Rome Statute, but how the ICC has conducted itself since. So you'll be aware of the Valerie Oosterveld calls it a constructively ambiguous definition of gender in transitional in the Rome Statute Article 7.3, and I mean I buy into that. I think a lot of a hard battle was fought to open space in that definition of gender for people like Colombia Diversa and others to make an inclusive argument for a gender definition that rejected the binary notion, that embraced more diverse and inclusive definitions of gender. And indeed in 2014, with the Office of the Prosecutor's policy paper on prosecuting sexual and gender-based crimes, what we saw there was the invitation for a more inclusive definition of gender was taken up in important ways. The Office of the Prosecutor did adopt a more inclusive definition of gender in that policy paper. I think arguably less has been done in terms of operationalizing that more inclusive definition in the OTP's work, and that remains to be seen. And this is where an intervention like orders of prejudice is so important, because it does the sort of essential legal work in enabling others to make the arguments that need to be made. And on that note, I want to say one of the significant contributions that I think will stand in terms of the book is the very frequent and appropriate integration of human rights law with international criminal law and indeed domestic Colombian law in articulating this argument around the systematicity of violence against LGBT groups. And that reliance on international human rights law is absolutely appropriate. It's appropriate because we have amazing people like Victor making the argument routinely, but also because the Rome Statute does itself in Article 21.3 list internationally recognized human rights as a source of law for the ICC. And I, in the introduction mentioned, I sort of relatively recently finished a book on women's rights in armed conflict under international law. And I did look at this question of, I was particularly interested in how different regimes of law were relating to each other. And what I found pretty consistently in looking at the ICC was that the court has been reticent to take up human rights law in its reasoning outside of reparations. There it seems to have been much more open to a role for it in human rights law. But the problem wasn't just, or the issue wasn't just with the court actually, the issue was also with those who were advocating in front of the court. So petitions, amicus curiae, etc., we're not relying on human rights law to underpin more gender inclusive arguments. And this not only pertains to sexual and gender minorities, just more broadly. And what this book I think has done, and one of its important legacies will be actually in showing us how human rights law can be an important interpretive tool in securing a more inclusive definition of gender in international criminal law. And that is done very systematically throughout the book. And I encourage others to read it for that purpose. And I hope that this will underpin continuing engagement by Colombia Diversa and others with the ICC in attempting, really there is a need to educate, frankly, I think the ICC and those who work with the ICC as to the value of human rights law if they are going to move outside the shackles of whatever shackles are presented by Article 7.3 in terms of definition of gender, and also, frankly, moving outside of state resistance to some of these issues. So I want to particularly sort of thank you and acknowledge that contribution from the book. And to encourage you really to do everything you can to pursue that, I think, in all engagements with the court or with the OTP, and it looks now like we will have a new prosecutor soon, so that should hopefully be an opportunity. The other areas of interest to me around the book, I was particularly interested in the discussion around forced displacement. This, of course, I mean, this is obviously in the Colombian context, I mean, it's absolutely understandable why it's such a focus. In international law more broadly, we see remarkably little remarkably few consequences for forced displacement for those who engage in it. And part of that has been around quite a restrictive definition of forced displacement, and particularly this question of if whether or not an order is required as an element of the crime. Thankfully, Colombia has moved away from that more restrictive definition, but that definition is still very important in international law more broadly. And that strikes me again as very important in the sorts of international implications of this book, where Colombia can lead the way, and where civil society actors can advocate for that more inclusive definition, because without that, we are not actually going to see meaningful accountability for crimes of forced displacement. Instead, I mean, frankly, it seems to me that the international policy scope has sort of given way on forced displacement. Instead, we talk about internal displacement as a policy priority, rather than talking about forced displacement as an international crime. And the fact that the book has been very, I think, robust in reinforcing the prohibited nature of that offence, and of course in giving the essential context around its gendered character in Colombia. And then another thing I think I particularly appreciated about the book was, and this has already been referenced, but the reliance on feminist theory to build the argument around the systematicity and persecution of LGBT individuals in the conflict. This, to me, I mean, this is important, obviously, theoretically, it's important conceptually, but it's also really important, it's important politically, actually, in building alliances, in building the sorts of civil society and other alliances that will secure the sorts of gains that we're looking for. I mean, I hope that it appears this is not the case in Colombia, but certainly there are plenty of places where LGBT advocacy groups operate really in parallel to women's organizations and women's groups, and don't see themselves as natural allies. And actually theory has been quite important in that, because there's a lot of theory on, a lot of queer theory, masculinities theory, that doesn't cite feminist theory. And those silos exist in all sorts of ways, and they reinforce each other. And I was particularly appreciative of the ways in which the book was just determinedly a feminist intervention for a queer inclusive definition of crimes. And actually that seemed quite unfamiliar to me. I had not seen that elsewhere, and it was yet another, I think, important contribution and legacy of the book. Yeah, I think then I'll just sort of wrap up with a few comments, I think, on what I would hope to see done with the book more broadly. So the 20th anniversary of the WPS resolutions was referenced, which is, of course, coming up now in October, sort of frighteningly for those of us who've been around for a while. And those resolutions have justly been critiqued for their exclusions on gender grounds, that they absolutely use the term gender as a synonym for women. If we look at how, in fact, they are often very careful in not using the term gender. We have had very little meaningful reference to sexual orientation and gender identity. There's massive resistance within the council to that interpretation of the WPS resolutions. And again, what the Orders of Prejudice does is it gives us an evidence base and a legal argument to contest those exclusionary definitions, and really to call the international community to account for its commitments. If it is to be made, if those commitments are to be meaningful, they will need to be more inclusive in their understanding of gender. And I think we can't really continue to collude in a sort of gender as a synonym for women policy and legal framework. The time has passed for that. I talked about the importance of international human rights law in the overall book. It's something that I will take with me. But we also, frankly, need to be conscious of the exclusions of the human rights system. So Victor's office comes out of the charter-based system from the Human Rights Council. The treaty-based system has been more variable in its recognition of the rights of sexual and gender minorities. And here I think, there's frankly much work to be done by the CEDAW committee in improving its understanding, recognition, and protection work for the rights of lesbian, bisexual, transgender women. And my hope is that this sort of work will be, again, an opportunity to really reinforce for the international community more broadly, including organizations like CEDAW, that it is not, it really is, it is not acceptable to say that you work for women, but to assume that they are all straight. And that will, this book, I think, gives us, again, that important kind of evidential and empirical basis. And I hope that, really encourage Colombia Diversa to try to engage with the CEDAW committee on this question. I hope you will provide the book to them, talk to them about the human rights basis of what you're doing, and encourage them to be bolder on this issue. Because if the CEDAW committee is not leading on this, then where do we look in the human rights treaty system? And then I think very finally, this has come at a really opportune time in terms of the work of the Special Rapporteur on Transitional Justice, in terms of the appointment of the new Chief Prosecutor at the ICC. I think in terms of sort of where we're at in international thinking more broadly. And it seems to me that this book will be absolutely important, unique, and its legacy, I think, stands to be potentially really quite significant across not just international criminal law, but even more broadly, I think, in international law and the protection of rights of sexual gender minorities. Thank you.
Thank you so much, Dr. O'Rourke. I think I speak for Daniela and for Colombia Diversa and for myself that we're also incredibly flattered to hear you say all of these things about the book, and that it connected with your research and with your expertise, and that it spoke to you on that level. And I also want to pick up on a few of the things that you said and sort of circle back to them. The first being, you mentioned that the OTP's recent report does include sort of like a broader definition of gender, but that there's much less work done being in terms of operationalizing. I have issues with that word, my bad. Operationalizing that definition. And that's actually a very common problem, not just in the OTP, but it's something we've encountered everywhere in sort of the framework and the sort of the architecture of the peace deal and what it means to be involved in peace building and in transitional justice as LGBT people. And even for human rights in general in Colombia, right? Colombia has one of the most robust human rights frameworks for LGBT people, not just in Latin America, but in the world. But those rights don't always become a reality. In fact, they often don't become a reality. And one of the reasons for that is the ways that what's on paper interacts with the limitations with the armed conflict and sort of the limitations and or lack of desire or interest of the government to actually intervene on behalf of LGBT people. In fact, we've seen many cases in which LGBT people finally decided to report to the authorities, which is not common, but they finally decide to, and they're turned away. Or they're told that, like I said before, the violence is just not serious enough to investigate, not by the Attorney General's office here, not even speaking about the special jurisdiction. So I think that's an important to point out, that sort of implementation gap that we're constantly sort of fighting back against, and that takes what's on paper through the sort of more human system of legal practice and of the state. The second thing, which is on forced displacement, it's also very interesting that stood out to you, because that's actually was one of our bigger concerns producing these reports as well. The sort of the threats which we treat as outrageous upon personal dignity and forced displacement. That was one of the conducts that we were concerned were not going to be of interest to the special jurisdiction for peace, right? That because once again it was going to be seen as minor crimes or lesser violations, that they weren't necessarily going to take a comprehensive view of what it actually means for an LGBT person to be displaced from their territory, especially, like we say in the book, when it's a Black LGBT person from a region like Tumaco, where there is a very strong connection between the territory, the family, and their culture, and leaving that produces very dislocation and culture shock, right? That they wouldn't see the gravity of those impacts. And so, that was also very important for us. And so is the reliance on feminist theory. We've also seen that tendency to silo in many countries across the world. And at times it has happened in Colombia, but we are very fortunate because we work in alliance with the feminist movement here. And in fact, many of the reflections that are included in the book have come out of conversations or debates with sort of our feminist peers and other organizations, women's rights organizations that work on sexual violence, especially, but also reproductive violence and other forms of gender-based violence. And so that's been a very, a source of inspiration for us and very important. And I'm sure Daniela will touch on it soon, but I do want to highlight that it has been a very important sort of point of a connection and of advocacy for us. They've helped open a lot of doors for us, and I think we've helped enrich sort of the understanding of gender-based violence, which is not just gender as a heterosexual cisgender woman. And finally, you also mentioned that Colombia is leading the way on documenting gendered harms like this, and even before the Justice and Peace process, actually one of the things, sort of the Colombian LGBT people became sort of like recognized and consolidated as like a social sector with the El Caguán peace process in the early 2000s, right? When they started being, becoming involved in peace building. And so LGBT people have been at the forefront of peace building for 20 years now. And I think that's something that is worth bearing in mind. We are part of that tradition as well. And, Alejandra Suero, who is an anthropologist and lawyer, who is currently also an SJD candidate at Harvard, was in our panel last week, our Spanish event last week. And she also reminded us to think about this in terms of fitting into other histories as well. One, like you mentioned, sort of, the history of questioning and then rethinking systematicity within the Colombian feminist movement, which dates back at least, till 2008. As she mentioned, we are also part of that tradition. And we're also part of a broader tradition outside of the feminist movement in Colombia of rethinking context analysis and how context analysis can be used to prosecute system crimes. And I think that's something the ICTJ has actually been at the forefront of and helped the Attorney General's office here in Colombia sort of rethink that as well. So we are sort of at the intersection of all of these histories and also at the intersection of sort of a broad exclusions that come out of the law, transitional justice, peace building, and that's what this is trying. It's all trying to question all of those exclusions, drawing on all of these traditions. So thank you. Now I'm going to turn it over to Kelli Muddel. Our second expert, like I said, Kelli Muddel, is the director of the Gender Justice Program at the ICTJ. She has been with the ICTJ since it opened its doors in March 2001 and with the Gender Justice Program since it was created in 2005. Within the GJP, Kelli has provided technical assistance to women's groups and policymakers in over 15 countries on how to design and implement transitional justice measures in ways that address gender-based violence and are responsive to the gendered consequences of human rights violations. These countries have included Tunisia, Nepal, Uganda, Sierra Leone, Colombia, Israel, and the occupied territories of Palestine. Kelli has conducted and overseen research projects which have contributed to expanding the way in which transitional justice as a field has conceptualized gender issues and conflict-related harms. These topics have included how transitional justice mechanisms have failed to address the targeting of sexual minorities during periods of conflict, the way in which measures of truth, acknowledgement, redress, and reform have grappled with sexual violence against men and boys, and the gendered consequences of the crime of enforced disappearance. She has an MA in International Political Economy and development with a concentration in development studies from Fordham University. Thank you so much for being here, Ms. Muddel. Take it away.
Thank you very much. And let me know if at any point you're unable to hear me. I must start with first thanking Colombia Diversive for the invitation to take part in this panel. It's a real privilege and honor, one, to be in a panel and a larger introductory panel with such distinguished people, but also to be given the opportunity to comment on this groundbreaking work that's been done. It really, I can't actually really express and put into words how exciting I find this work and what it means that you have been able to push forward, I think, in leaps and bounds where the field has been at on this issue. I have sort of two sets of comments I'd like to make, which come with a few questions for you, Daniela, to get your insight. No, don't be afraid. And the first is sort of around looking where this work fits in the evolution of the transitional justice field when it comes to taking a gendered approach. Because I think there are some lessons there that may be interesting to see your reflections on in terms of what challenges may be faced in, now that this work exists and this body of evidence exists, pushing it forward into practice. The second is more about how to use this work and get your insights on how to use this work in other countries that maybe don't have the legal protections that Colombia does, or the strong LGBT rights community, or the infrastructure. And so I'd be curious from your perspective and the role of Colombia Diversa, what you would say to other countries, what advice you would give to build that momentum to long-term change. And then also incorporated in this is the element of really trying to suss out and ask about what you see and what the victims you've worked with see as the long-term contribution that this work can make to societal change in Colombia. So that's just putting forward those areas before I start. So on the first point, on the evolution of the field, on a personal note, and this is just to kind of give you context of where the field was when early on at ICTJ in 2005, this was one of the first areas of research that the gender program proposed. And it was met with a pretty intense resistance. And the resistance and the sort of concerns echo a lot of the things that you list in the book as in your historical analysis of definitions of different legal concepts, but also sort of the pushback that has come in taking these violations seriously. So it was, initially, well, this violence it's random. It's not a part of the conflict. And so how can you even consider it when you're thinking of a transitional justice mechanism? Because it's just normalized violence in society. So therefore, you need to have a policy. You need to get hold of evidence that shows there is a specific policy by armed groups to target it. And even if you do that, the next sort of wave of resistance was around hierarchy of violations, which is something that has been mentioned, is that do these violations, is it arbitrary executions? Is it torture? Is it enforced? Is it enforced disappearance? Because if it's not, then let's not waste our time in investing resources on it. And then the final sort of level of resistance, and this has been mentioned as well, is the assumption that the numbers are so small in terms of victims comparatively to other categories and other types of violations that are suffered, that why would we waste valuable resources investing in outreach and trying to take statements and trying to pursue some sort of accountability or truth for this very, very tiny limited category of victims in the universe of victims in these contexts. And I think that shows you where, in some ways, the field started. I mean, the field existed before 2005, but where it started at that point, and the field has evolved in many ways since then, in terms of what types of violations it looks like, in terms of what a gendered approach to transitional justice is. But on this issue, it's really stayed stagnant. And I think this speaks to what's been brought up before about there's a lack of information about how LGBT individuals are impacted by conflict. What are their experiences? And there's also, in many contexts, a lack of ability for those victims to organize because they don't have the legal protections to do so. And so there hasn't been an effort to really move this forward in terms of, in many ways, I mean, some but in many ways, in many contexts, where you could do what you've done in Colombia, which is produce this body of evidence and this argument. And if you look at the one example of where I think a transitional justice mechanism seriously took these issues and tried to incorporate them, it's the Peruvian Truth Commission. And that was a series of, and I think maybe someone who worked on that Truth Commission, maybe in one of the attendees that I saw. So a lot of my information comes from interviews with him, while it was well known that this was a tactic that included in the social cleansing campaigns, particularly gay men and trans women were targeted. No one really was researching it or looking into it. It wasn't made a priority. And so it came about in this very haphazard way where there was a memorial where one of the Truth Commission employees started asking these groups about, well, what is this memorial for? And why haven't you submitted to the Truth Commission? And they said, well, outreach hasn't been made to us, and also it's not going to go anywhere. And they took that up, but the only way they could take that up and then put it into the report was because they had to then troll through tons of documentation to find written proof that this was a policy of the armed groups and that it had been explicitly stated. And they were able to do that. But this was the work of a few people who, in some ways it was an accident that they were able to access this information. And so I think to look back on what has happened since the Peruvian Truth Commission and to be able to signal that that is one of the most significant advances to date, I think really places and emphasizes how important your book is and the work you've done is, because I think it has catapulted the way these issues are looked at and are hopefully dealt with in the field of transitional justice. So I want to briefly just talk about, and you can spend days talking about the evolution of the field when it comes to a TJ, a gendered approach. And I don't want to do that. I want to give you a very oversimplified view of that, mostly to talk about the resistance that each of these advancements has faced, because I think that is really important when you think about both in Colombia, but also those of us outside of Colombia, how we use this work and how we push it forward, both at the global policy level, but in country. So the oversimplified sentence evolution of how the field has advanced in looking at these things is sexual violence against women is a serious crime. We need to put provisions in place to reach those victims, and we need to address those. And I'm talking about transitional justice mechanisms more broadly, not just criminal justice procedures. And then at the pushing of feminists and gender activists, it moved into, well, sexual violence isn't the only way that women may be particularly impacted by conflict. So we need to look at the gender dynamics of conflict in a broader way and see how human rights violations are experienced very differently by men and women, which then impacts the harms that they face. And this took pushing because in part, many people within the transitional justice practitioner side said, you're overloading a transitional justice mechanism if you add this. You're overloading a truth commission. You're overloading a reparations program. So that was part of the resistance, but there was also, once again, this need to actually prove that this was the case. And so I think a lot of work that's been done around enforced disappearances and the impact on wives and sisters and mothers is a good example of how that has moved forward. And then around the same time, there was the sort of debate of, well, sexual violence is primarily directed at women, doesn't really happen to men and boys. And even if it does, it's at lower numbers. And so do we really want to focus on that? And I think this resistance, I raise these things because I think it shows particularly a concern. I think it shows a dilemma with how the field evolves in terms of these issues and broadening the concept of gender and looking at structural discrimination that we as practitioners face, those of us who believe it should be evolving, but also it highlights, I think, the resistance, and this is, all this is a personal opinion, but this is particularly a personal opinion within the global policy level, and when we're talking about the women, peace, and security paradigm, and trying to get them to adopt these broader definitions and not treat gender as binary. And so some of this resistance is understandable, because while we've advanced in many ways, we're still fighting the very basic battles in many contexts of sexual violence has actually happened, and maybe you should address it. And so there's a need to be vigilant and to keep pushing on that front. Sometimes the resistance, I think, comes from a fear that this will fall on women's rights organizations to take care of. And they feel so burdened by the number of victims they are already trying to address that if you add sexual violence against men and boys and those victims, or if you add the issue of the targeting of LGBTQ groups, they can't deal with that. And I think that demonstrates the broader human rights, civil society sort of often rejection of, well, this is a gender issue, well, then women's rights groups needs to deal with it. I think on the policy front, things that I have been faced with when doing presentations on this issue, you know, in large conferences around women, peace, and security, and I've been asked specifically to speak about these issues, broadening the concept of gender, and also specifically about LGBT abuses, is we don't have enough resources to do what we want to do now, so we can't. And this very strong concern that it will undermine or threaten the women, peace, and security agenda, because governments, member states that maybe have just been able to sign on to having a 1325 action plan are not going to go anywhere near it if it includes this more nuanced and correct version of how gender exists and how gender constructs are made. And so these are sort of I think the challenges that we run up against. And I don't have any good answers to them. And I feel like it often feels a bit like a balancing act of needing to be vigilant and safeguard the advances that have been made while also pushing back and trying to evolve the field further on how it looks on these issues. And I think your book has provided, as was stated before, significant, nuanced, sophisticated legal arguments and evidence to show how these things are linked, and how, and this is where I think the most compelling argument maybe is, if we're really committed to prevention, and if we're really committed to issues of guarantees of non-repetition, clearly, by the way, we have framed our handling of sexual violence so far, it's not working. And I think in part, it's because, and this is not entirely, I mean, I say this in a very blanket statement, but it's not true of many people who are working on this and on the ground. But in part, this is because people are seeing there's such a narrow focus on the type of violation and the category of victims. So take sexual violence against men and boys. That's now becoming a more popular topic, but it's seen as you're just adding another category of victims to this. And there isn't the sense, and so finally you've worn us down, okay, it happens, we'll include it in the language and resolutions, but there isn't this drive to really look at what are the motivating factors behind why this type of violence is used, and what are the intent of perpetrators, and how is that shaped by social constructions of gender and sexuality and the policing of those. And I think your book really just is astonishing to me, because it takes this analysis, and it's done in such a clear way when you look at the two areas in Colombia, and it's backed by such sound field work that it is so easy to see how these elements of socialization, prejudice, discrimination shape the way perpetrators act as individuals, but also how armed groups use the vulnerabilities of LGBT groups to target them, but that it's also part of their ideology. That it is very clearly linked with what drives them to fight and to try to control populations. And I think until we start to, and when I say we, I mean everyone who's working in this field, starts to understand that and starts to really be able to understand the contextual analysis and delve into that and apply it in looking at these types of violations and at who is targeted and who is made invisible, we're not going to get to, we're really going to fail at contributing to guarantees of non-repetition and to really trying to prevent this type of violence from occurring again. And I think your book just really, like, it's, and I know I keep saying this, but it really just is amazing in pushing these issues forward. And I think it's a huge contribution. So my first question to you coming out of that, and that was the longest section, is I know you did consultations with international experts when you were doing the study and writing the book. And I'm curious sort of what, if you faced pushback or resistance to the arguments you were making, particularly maybe around legal practitioners or international women's rights activists. And what pushback did you face in Colombia when you presented this, if any, to the special jurisdiction and then the submission to the Truth Commission? My second point, which is a lot quicker, is this idea, it's linked to this, is this idea of how does this contribute to long-term change? Because we know there is, I mean, it's not surprising that such an innovative piece of work has come out of Colombia, because as one of my colleagues said the other day, that the most advanced thinking on transitional justice that has ever been incorporated in any context is in Colombia on any issue. the laws that you create are incredibly sophisticated and really sort of are picture perfect. But as we all know, even with the infrastructure and the resources and the high capacity that Colombia has, there is often a gap between policies and how transitional justice measures are set up and how they're implemented and how they're actually able to address the expectations of victims and deliver. But there's also, in this particular case, because the societal prejudices that exist have fueled this violence and are integral to the way this violence has been used in the conflict. There's clearly a huge societal gap between what the legal structures are in Colombia and what the perceptions and discriminatory practices are of communities and families. And so I'm wondering, and I know this is a kind of an impossible answer or question to answer, but what do you see what is your hope that the Truth Commission and the special jurisdiction will do with this information to contribute to the long-term change of impacting those societal prejudices? And how do you see this as going beyond just if it is mentioned in a Truth Commission report, or if the special jurisdiction would take it up? What is the impact you want to see or you think it can contribute to in society in terms of long-term change? And related to that is the issue of how we can apply this in other countries where their LGBT individuals are not a protected class in often cases. Organizing is incredibly difficult and sometimes illegal. There's ongoing significant government repression of these people. And so, from a context like Tunisia, where many individual freedoms are not seen as respected or needed or enshrined in law, where many of the activists who organize are underground, and there's pushback from even the idea of when the Truth Commission was created and there was a women's committee or unit that was created under it, that gender couldn't be the title of the unit. And that was the breaking factor for many of the commissioners, many of the male commissioners, because they thought that opened the door to issues of gender identity and sexual orientation. And those compromises have to be made in those situations. But how do you see this as the work of Colombia Diversa that you've done both here, but also before this? What lessons or what tips would you give to activists in countries like Uganda, where there's intense repression, countries like Sri Lanka, where there is organization and it's small, but it's dismissed by those establishing the transitional justice mechanisms, that were to be established, and the quite vibrant civil society as you can't be a part of this conversation because you're going to derail everything. So sorry, once again, we're back to the small numbers. You need to just wait your turn. And so I'm really curious from your experience in Colombia, what advice you would give to building up for these other countries to build up to the moment that you are at now. And that's it for me.
Thank you so much, Ms. Muddell, for all of your comments and insights from so many years of working on engendering transitional justice. I think all of that is very helpful. And before I hand it off to Daniela to answer some of your questions, as well as some other questions that I think came out of Dr. O'Rourke's presentation, I'd like to pick up on some points as well. The first one, and I won't belabor it because I know that Daniela will go into depth, is that we were met with significant resistance from practitioners and from lawyers and judges with regard to our efforts to sort of carve out a space for LGBT people in the jurisdiction for peace. And since she'll go into the details, I'll just say that in many cases, sort of the perception was that the natural place for the LGBT people was the Truth Commission. Right, you know, where you could really just like analyze and you know what happened to them, but there really was no hopes, there was no prospect, no real prospects for justice because these categories were so restrictive that the violence just didn't fit. Right, you know, going back to something that Victor said earlier, you know, that his mandate is in part to make things visible. Right, these categories render these forms of violence invisible. Even though in society we see them all the time, even though the armed groups see them, even though the state actually does literally see them and turn people away, in the eyes of the legal standards, they don't fit. And so that's one point. And that was, you know, actually, for example, going back to an earlier point, and again, from Dr. O'Rourke's presentation, with forced displacement, right? Since there is that hierarchy of violations, and the question is always like, oh, okay, is it an arbitrary execution? No. Is it torture? No. Is it sexual violence? Even, right? And the answer is no, it's not, but that doesn't mean that it's any less grave. Even if it does occur, you know, quote unquote, in small numbers, especially because the impact is so far reaching. You know, something I said recently is, you know, the violence against LGBT people ripples outward. It has the power, one case, one threat, one homicide, one forced displacement has the power to break up entire LGBT organizations, displace entire LGBT communities, force entire LGBT groups sort of back into hiding. And that's not a lesser issue. That's something that has to be at the forefront of the conversation. The second thing is that you also mentioned is that, you know, in some cases, part of the problem is that we're still fighting basic battles. And I think that is also to an extent true here in Colombia, especially with sexual violence. Part of the reason why Colombia Diversa and a coalition of other feminist and women's rights organizations have called for the head to open a national case is because they're struggling to recognize that sexual violence is a part of the conflict. And again, I know Daniela will go into more detail about this, but just to put that on the table, you know, it's not a one battle, you know, not just yet, even if there are so many even if the most robust sort of gender standards in international law are around sexual violence, we are still fighting for, you know, these tribunals to actually recognize and investigate them. The next thing is that in part, this also stems from the narrow focus and sort of that drive to, like you said, with, you know, sexual violence against men and boys, sort of instead of questioning the underlying logics of the categories themselves, to sort of just try to broaden them, right? And try to fit as many new categories as we can in there, which is, it can be important and can be an important tool of justice, but in this case falls woefully short. And that is why, you know, even if, for example, with the definition of gender in the Rome Statute, what we are trying to do in a sense is sort of broaden the category, with something like systematicity, which again, Daniela will go into, we're trying to question the underlying logics of the category. Because they are built from a heteronormative, cisnormative, masculine perspective that doesn't think about structural violence and doesn't think about how sort of like those systems of oppression can give rise to forms of violence that are still conflict related and that cannot simply be reduced to sort of individual excesses, quote unquote, or to individual prejudices, which is, you know, also something that we're often told, right? This is just because this guerrilla member was, you know, he was raised to be homophobic. And so of course, if he becomes a guerrilla member, he's going to be homophobic, right? And completely erases sort of the link to the conflict. I'm also glad that you mentioned the Peruvian Truth Commission because, you know, they, you know, like you said, they sort of happened upon, you know, LGBT harms against LGBT people. And they were one of the first to actually mention it in the report, even if, you know, they didn't go into depth. And they mentioned for the first time something that we also explore in the book, which is that armed groups gained legitimacy by attacking LGBT people. right? It was a one-liner, but it was an important one-liner because it is one of the main reasons, especially in areas like Southern Tolima, where, the birthplace of the FARC, it's one of the main reasons why they attack LGBT people, why they spend years trying to correct them before finally realizing that there is no correcting them and that they have to go. And that makes them, it's a signaling mechanism, right? It draws them closer to the local population, makes the population believe that there's a shared value system that they can build on together. So I think that's very important. But what we also wanted here, and what the women's rights movement and what the LGBT rights movement fought for in the peace agreement was for them not to have to happen upon these violations and these harms, right? For there to be a mandate and gender sensitive officials in each of these institutions so that, it was something that they had to think about from the beginning, right? That they were sort of obligated to think about from the beginning. And that has been particularly useful to us, and particularly useful, I think, also to the officials in these institutions who believe in these issues, but who are also sort of, struggling with other, coworkers who don't necessarily believe in those issues. And they've told us, this has been the fact that, we have this mandate is a key tool for securing buy-in from other people and for convincing detractors, not just within the institutions, but outside, for example, with the fundamentalist movements, that we're seeing attacking these institutions or, the parties attacking these institutions to sort of, be able to stave them off and say, like, look, this is our mandate. This is our legal mandate. We're not doing anything we are not supposed to be doing. We're doing exactly what the law tells us to do. So that's also very important. And in doing so, it's also helped us find allies, right? Helped us find allies to sort of push this implementation along and sort of help prevent or help close that implementation gap that you also spoke about, between, what happens on paper and what actually ends up being implemented in practice. Because even if, in theory, in the peace deal and for the transitional justice institutions, gender is supposed to be sort of a central axis of analysis, right? Not an afterthought, but rather, un enfoque transversal. It's supposed to be at the core of how people think about each of the issues. Actually doing that, mainstreaming it, even when there are best practices like specific groups in each of the institutions dedicated to gender, which is something that the ICTJ has also called the best practice, even when there are specific groups dedicated to that, is still hard. Because you have to, like I said, secure buy-in and interest from all the other parts of the jurisdiction, of the Truth Commission, of the unit for the search of persons deemed disappeared. And so I think those are all very important issues that you brought up. And so now I would like to turn it over to Daniela and give her a series of questions that have come out of both Dr. O'Rourke's and Ms. Muddell's presentations. The first of sort of thinking more about Dr. O'Rourke's presentation, Daniela, I'd like for you to talk to us a little bit about why it was so important for you and for us and for Colombia Diversa to draw on feminist theory to sort of reinterpret the three key categories that are at the center of this book: systematicity, patterns of violence, and persecution, and along with persecution as a crime against humanity, the definition of gender in the Rome Statute. Why did we feel the need to turn to that source, beyond the law? That's the first one. Second, now drawing on Ms. Muddell's presentations, speak a little more about the pushback that we faced in sort of trying to sell, or for lack of a better word, these ideas, and trying to actually get justice for LGBT victims in Tumaco and in Tolima, but also in Colombia as a whole. And what pushback did we face from practitioners, both within and outside the Special Jurisdiction for Peace? The next question is, again, drawing from Ms. Muddell's presentation, how do you think this is going to contribute to long-term change in Colombia, in terms of impacting those underlying structures of prejudice? And the last one is, what would you say are the lessons we've learned, and how can they be applied to countries where there aren't robust protections around sexual orientation and gender identity, and where there isn't as much space, because in Colombia, despite the fact that there was a 50-year-long conflict, which really has not given way to peace yet, there is still more room to organize and speak up and advocate for these issues than there are in many other countries around the world. So how would you say that these arguments, these strategies can be applied or can speak to those contexts as well? So I turn it over to you.
Can I?
Oh, yes, go ahead.
Totally abuse my power to unmute and just add a sub-question to the issue of the impact in Colombia, I had meant to ask also, not only what do you hope the impact is, but also in working with victims, what are their expectations of having participated in this project and knowing that these submissions have been made, and what are their priorities in what they want to see happen?
That's a wonderful question. I'm glad that you did not abuse the power of unmuting to interject it. I think that's a very important question to consider as well. So Daniela, that is also part of the set of questions that we're now directing to you.
Hi everyone, can you listen to me? I'm having problems with my English, not with my Wi-Fi connection. I'm sorry. Can you hear me? Okay, thank you very much. So, well, thank you for all those questions. Thank you for your remarks on the book. I'm feeling really humbled by all the comments you just made. So first of all, some acknowledgements are mandatory, and excuse me in advance for my not so eloquent English. I'm very pleased to be virtually gathered with people I've been admiring for so long. Dear Dr. O'Rourke, you were one of the first scholars I read when getting involved with the discussions of gender and transitional justice, maybe 7 or 8 years ago. And having you here commenting this book is an honor I can hardly put in words. Actually, my younger miss thrilled, amazed, and shouting in her bedroom and jumping over her bed right now. Dear Kelli, you were one of the first international experts on this topic to listen to our litigation strategy before the Special Jurisdiction for Peace, and your inputs and enthusiasm were a key for our decision to publish this book. We are very grateful to the ICTJ, especially Anna Myriam, for committing to make visible our work and for being here today too. Dear Victor, you are definitely one of the most admired lawyers. For me, I follow your career in the Inter-American system on human rights and also your academic path at Harvard, and I'm humbled by your presence here today. And of course, I have to thank my partner in crime, Lucia, who left everything not only to translate this book, but to edit in such a way that it was easily understood by English-speaking readers, actually to overcome the major problem of my very Latin and Baroque style of writing. Thank you for making this journey of research, advocacy, and personal growth along with me. I'm very happy this publication represents the closure of our work together for this time only. And now to the core of this discussion. So regarding the topic of the concepts we try to intervene with this work, as Lucia stated, and you all have said, we had an assumption when building this book, and it was that in armed conflicts and in situations of widespread human rights violations, such as authoritarian regimes, people have been persecuted because of their sexuality and gender. And the long-lasting Colombian armed conflict has not been exception to that rule. So, as Lucia stated at the very beginning of this presentation, we tried to respond to questions here: how to address the historical deaths to lesbian, gay, bisexual, and transgender people victims of the Colombian armed conflict, and how to achieve this goal by using a hyper-technical system, which is the law. And with this, we had like another assumption that was why law is a problem, why law is problematic. And here I want to address something that Professor O'Rourke said at the very beginning of her presentation. Well, in her presentation, it was very important for us to use feminist theory to accomplish these goals, because we understood that when we started making this problem, we also faced these divisive approaches to gender-based exclusion and oppression. And this is actually currently happening here in Colombia very dramatically. It's a very as I see it, a very dramatic division between LGBT movement and feminist movement, especially in the issues of the scope of the political subject of feminism. Can transgender women be part of that subject? Well, there's a major part of the feminist movement here in Colombia that denies a place for transgender women in feminist struggle. So what we try to do, and what we're trying to do every single day in Colombia Diversa, is to make that alliance with the feminist movement. And that is why we feel committed to recognize that this product, this specific book, is part of the legacy from our feminist colleagues here in Colombia and worldwide. And our bet is to recognize that LGBT plus people's struggles have a place in feminism, and that feminism is necessary conceptually and politically to put a framework for that struggles. So what we learned from this feminist approaches to transitional justice from people like Professor O'Rourke or Professor Fionuala was that law is not constructed to comprehensively embrace the needs of people who are oppressed or excluded from society because of their sexuality and or gender identity. And the second thing we found out was the ones called to apply the law are constrained by a complex social and cultural scheme that reproduces these forms of exclusion and oppression. So their decisions can be also a reproduction of these social and cultural schemes. But what we found out too from our feminist colleagues was that this does not mean that the law can't be read and interpreted through a feminist lens and become a tool to the service of the causes of women and LGBT people. So what we did was actually to put this feminist lens to understand some of the more complex and fundamental elements of contemporary transitional justice, specifically regarding the international criminal regime, which has led, which is directly applicable to the special jurisdiction for peace here in Colombia. So the first notion we intervened was the notion of systematicity. Why? Because peace agreement, constitutional reform 01 of 2017, and the jurisdiction's statutory statute put the accent on the investigation of crimes with these characteristics, not systematically committed crimes. And because what predominates over the notion is the idea of a comprehensive planning of criminal plans or policies. What we propose from the learning that we have had from our feminist colleagues is to understand that when an attack, when an attack against civilian population is committed in context in which cultural and political frameworks articulated by forms of domination, such as the sex-gender desire system, predominate, in which there is also an armed confrontation that reinforces and deepens the system, it is unnecessary for the victims to prove the existence of a specific plan or policy aimed to violate them or to rape them or to enforce forcibly displace them, because the context is on its own enough evidence of the dominance of this system and regime. And this also helps to understand that this violation is always organized, rational, and non-random. So the next notion we try to intervene with this work was the notion of pattern, which has become increasingly important in the international criminal law as well as in the domestic criminal law to prosecute major crimes and major human rights violations committed in the context of the armed conflict. So what we did with this notion was to make a specific, to try to make it directly and very specifically separate from the notion of systematicity, to understand that they are not the same, they are not equivalent notions, because what we saw, especially in domestic criminal law, was the judges were interpreting the notion of pattern according to the Inter-American Court of Human Rights precedent. And the problem there was that the court tries to make them equivalent notions, pattern and systematic violence. So what we tried to do was to reinforce the idea that a pattern should be used as a mean and not as an end in itself, as I stated before, has happened in the justice and peace experience, for example. And it is helpful to identify a series of criminal behaviors, which implies a repertoire, with similar characteristics in their execution. It means a technique, and here we're following the Levy-Wood contributions to the notion of pattern. And what we say there is, this kind of acts are perpetrated by the same actor, and they are repeated over a certain period of time, but the frequency is not actually reliable here, because as you can see in the cases we presented in the book, sometimes these crimes are not committed closely in time, but there's a lot of time between one or several cases of prejudice-based violence, and then maybe 5 or 6 years in which we don't have any cases reported, and then we have another bunch of cases. So that's why we think like this frequency or the time element in the pattern has to be like moderated or put aside in the important in like the rate of importance of the elements of the pattern. And what we say is the execution of those activities does not necessarily respond to a plan previously agreed upon by those responsible, but is based on a set of moral and behavioral precepts to justify and legitimize such action. So what we say here is that it is very important to see if in the action there is some kind of materialization of externalization of the intent from the perpetrator. The identification of these elements applied to specific cases, as we try to do in the book, facilitates the testing of the system of domination in which is based the persecution or the different repertoires of violence committed against LGBT people in situations such as armed conflict, but not only armed conflict, other widespread or systematic regimes in which this kind of violence has been also committed. And the last thing we did was to provide a legal framework based on the logic of international crimes to present this violence and the violence victims were subjected. So our proposal was to identify this pattern under the umbrella concept of the crime against humanity of persecution, as all of you have stated before. Just a little remarks on the persecution of the crime of persecution. Persecution is the legal criminal equivalent, as we have stated, to the violence based on prejudice as an analytical category that has served us to explain and address the violence committed against LGBT people inside and outside the armed conflict in Colombia. And this is something very important regarding the questions of Kelli, because what we saw in this crime was the opportunity to address the idea that this crime are not severe, that they are not important, because they are committed to a very reduced group of people, or if it's widespread, which is not the case of Colombia, as you see in the book. This violence, of course, has the numbers of violence against LGBT people cannot be paralleled to the major numbers and statistics of violence, for example, in forced displacement, when we have 9 million people victimized, and then in LGBT reported by the officials, we only have like around 3,000. So even though this is not a massive, this is not widespread in the numbers, it is severe, and it, of course, what we try to prove also is that the gravity threshold is also met here, because the symbolic effects this has on other LGBT population, but also the effects it has on the citizenship of LGBT people who are being subjected to this kind of violence. This is very vulnerable people who commonly lives in very isolated places from the country that are not very well equipped by the state, and their relationship with the state and their communities are very often hostile. So with this kind of violence, we are reinforcing the idea that there are second-class citizenships, and that is very, as we try to say in the last part of the book, when analyzing the gravity threshold, that this itself is very severe and must be considered as an offense to the humanity itself. Well, I don't want to like prod more. I don't want to like have more time like explaining the thing on the criminal of the persecution crime. So I just want you to go to the book and see for yourselves the amazing work Lucia has done translating these ideas to English, maybe in a better way than I'm doing now, when I'm very, very nervous. But I want to address the other questions. So regarding the question of how to apply this argument in other cases aside from Colombia's armed conflict, and what lessons have we learned that can be applied in other contexts. Well, as you can see in the book, we're not the first ones to come up with the idea that the crime of persecution can be used to help LGBT victims from widespread or systematic violence to redress those victimizations before a state or international organizations such as the ICC. There's an example set out by Outright, Madre, and OWFI. As you know, they petitioned to the OTP under the Article 15 of the Roma Statute to open an investigation on gender-based persecution and torture committed by Daesh in Iraq and Syria. Lucia told me yesterday to pronounce this better. I'm sorry, Lucia, I'm defeating you. And there are other experiences from Latin America that are also very important. In Ecuador, for example, Nueva Conichel and la Fundación Regional de Asesoría en Derechos Humanos are seeking accountability for the persecution committed by police against transgender women in the 90s. They filed a complaint before the prosecutor's office in Ecuador on behalf of several victims, so to provide them with factual and legal arguments to open a case under the criminal law of Ecuador, which has a different recognition and application, which has a direct recognition and application of the persecution crime. So the penal or the criminal code in Ecuador states as a domestic crime, or has as a domestic, recognizes as a domestic crime, the persecution. So they can use their own criminal code to bring this kind of cases to the institutions. And we've seen in Colombia Diversa that there are other further cases in which this kind of arguments, not only the one of persecution, but the systematicity one and the patterns one, which we think will be very important to address the impunity that covers up all the violence committed against LGBT people in situations like armed conflict or dictatorships. One case is the one who is not, which is now been addressed by the Inter-American Court on Human Rights, the case of Vicki Hernandez against Guatemala. I don't know if you're familiar with this case, but this is a transgender woman who happened to be as a very important human rights defender in Guatemala. And when the coup d'etat became in 2009, she was murdered by officials from the police, and in the context of this widespread violence against civilian population during the coup d'etat, during the coup. So what we want to do in this case is to present a brief amicus to provide the court with arguments to set out that this kind of violence is systemic itself, like it doesn't come it doesn't come from the air. It is not, as I said before, it is not random. It is an organized violence. And I know I took a lot of time. I'm sorry. I'm not very used to speak this long in English. But there are other cases I'm just gonna list so you can have them like mapped. And these are cases that we are actually committed to in some way and in some time make some kind of intervention. The persecution of Black transgender women in Rio de Janeiro in Brazil, it's also a case for systemic violence against LGBT people that can be understood under these logics. The cases of gay people murdered by Sendero Luminoso in Peru during the armed conflict are also cases that were brought by the Truth Commission, as Kelly stated, but it has no recognition whatsoever in the judicial system. And Kelly asked us what kind of mechanism can we use to address this kind of violence if there is not such a sophisticated legal system as the one that has Colombia that permits the special jurisdiction for peace to directly apply the, for example, Rome Statute, no? Because our criminal code does not have the persecution recognized as a domestic crime, but since the special jurisdiction for peace can apply directly the Rome Statute to the crimes committed by the armed actors, then there we have like our hopes put it in the international criminal law. So we thought about the case of Chechnya, which is very, as you all know, it's a very dramatic case of persecution, judicial and assassination, and all other rather horrendous human rights violations against LGBT people, especially transgender women and gay men. So what we thought about this case is it could be prosecuted under universal jurisdiction. And of course, we understand the limitations of this kind of justice, as we have seen in the case of victims from Franco's dictatorship in Spain. But as we have seen also in that case, the use of universal jurisdiction can push at least the opening of a broader social conversation, which is at the end what we are very interested in. With this, I'm gonna close because I'm taking a lot of time. So what we want with this is not to see the responsibles and disconnect with the interest of the victims. They don't want to see their perpetrators in jail. That is not their purpose. Actually, to be very honest, what these people want is social justice, to have a dignified livelihood, that the state provides them with a dignified relationships. And as we've seen it, justice is not as important as to have a social context which is not so hostile to them. So what we try to do using the justice system is to understand the context in which we are. Colombia is a very fetishist country with the law. Here in Colombia, every single debate is a legal debate. So what we try to do, bringing these cases before the justice, is to understand and embrace that context, understand that public important discussions in this country are always imbued in legal discussions. That's actually our main goal. We know Truth Commission is very important, but Truth Commission here in Colombia is not going to be as important as what the jurisdiction says. And that's only because the legal differences between each other. The jurisdiction is a judge. The Truth Commission is not a judge. So since that is so important here in Colombia, we want to bring the discussion before the jurisdiction, because we know if they say in their sentencing or in the resolutions that there was a prejudice-based violence committed against LGBT people by armed actors such as FARC or the military, that this constituted crimes against humanity, that this was committed systematically in all the country, as we try to provide with the evidence of the cases we delivered to the jurisdiction, then we will have the opportunity to have this broader conversation that we know Truth Commission, as much as we love it, cannot bring to the context in which we live. But also because we think symbolically, it is important that victims have access to these formal judicial spaces. Because if we say them like, your case is not so severe, or the gravity threshold is never gonna be met, or this cannot be systematic, this maybe can be a pattern, but systematicity never, because there's not an amount of people or cases that can actually reflect on the idea of systematicity that is more hegemonic. What we try to do here is to say, no, if we want to transform this society, if we want to transform the violence which caused so much pain to the people we are representing in these cases, we have to tell them that justice is open for everyone, because that's one of the basic human rights for a citizen to have, access to justice. So with that idea, and I'm always this, at the end of my interventions, I always try to be this emotional, because this is an emotional work for us. These cases are so dramatic and so painful to hear sometimes that, yes, of course, we have an academic pretension to say that this can be rigorously analyzed from feminist theory, from very complex frameworks, conceptual frameworks, but let's not forget what feminism has taught us for several decades. These emotions we feel when we work are important in the work we do. They are political. They are the driving force for us. So with that in mind, I wanted to close my intervention. I know maybe I left some things out, but we can use this just as an opening discussion. And then again, I wanted to thank all of you for your patience. And I'm sorry if it wasn't clear enough. And well, thank you again for all your questions and your marvelous remarks on this book. And thank you again, Lucia, my friend, for being so committed to this. Even though this is not your country, you're telling everyone that frontiers are not important, but just what we do by heart. Thank you.
Thank you, Daniela. That was a wonderful intervention. I don't think there's any need for you to be self-conscious about your English, because I think that was perfectly stated. Yeah, goes without saying. So in the interest of time, I think what we're going to do is I'm going to highlight some of the points Daniela made, and then sort of a final round of comments from the panelists, taking into account some of the questions that were sent over. And I can address one of these right now, because I think it relates to Daniela's presentation. So the first one, in terms of systematicity, I think something that we need to take into account. Yes, of course, there's a difference between system and pattern, but a system like the sex gender desire system, like patriarchy, like compulsory heterosexuality, can give rise to a pattern of violence, right? Like Daniela said, a series of conducts committed in a similar fashion by one armed group over a specific period of time, and that those people can be held accountable for those actions. Because even though what happens is that these systems give them a script, in order to perform those violences, and how to punish people who sort of break with that system, they are still the ones that are taking advantage of that system, that are capitalizing it, operationalizing it for the sake of their war making. And that's what, in part what Daniela says when she talks about systematicity and the non-random nature of this violence, right? The fact that these underlying systems give rise to this pattern and give these perpetrators the script of violence on which to draw on does not mean that the violence is not organized or is not random, even if it emerges as a practice. On the contrary, the fact that we're even talking about a system denotes just how organized this violence is, and just how useful it can be to the armed conflict. And why it's not necessary for 3 guerrilla members to sit down and plan how they're going to sexually assault a trans woman, like it might be necessary for 3 guerrilla members to sit down and plan an ambush, right? It doesn't need the same level of planning, precisely because it's something that we're taught from the very beginning, and throughout our entire childhood. The second thing I want to mention is, in terms of legal fetishization, which is something that Daniela mentioned, that is how Colombian social movements have been described by, one of its foremost scholars, Julieta Lemaitre. And I think that's very important to keep in mind for this conversation, because of something that Dr. O'Rourke has said in her previous work, right? Armed conflicts and peace building after armed conflicts, these are the mechanisms that arise are sites of meta conflict negotiations, right? And if we're going to quote Dr. O'Rourke, and if we're going to talk about sort of the quintessential site of meta conflict negotiation in Colombia, it's a special jurisdiction for peace. Precisely because of this legal fetishization, right? This is where sort of the most important battles, for ironically enough, using that word, the most important battles over the meanings and the nature of the armed conflict are being fought. And if those are the most important battles, then how can we not try to carve out a place for LGBT people in the special jurisdiction for peace? Which I think is, again, one of the central drivers of this work. And to draw on something that, both, actually all of you have touched on today is, and Daniela mentioned as well, so part of the reason why I think the UN system, the Committee for the Elimination of Violence Against Women, and also the WPS resolutions is so important, is that so those tools which are apply universally can be used in other contexts where there aren't robust sexual orientation and gender identity protections. Because in many of the cases, for example, that Daniela mentioned, Ecuador, Brazil, we are lucky to have the Inter-American system, right? And the Inter-American system has recognized sexual orientation and gender identity as protected classes. But that's not the case in many other systems. And so that's why I think where the UN plays an even more important role. And so to open up this final round of comments, I'd like to sort of take up 2 questions that all 3 of you can speak to varying degrees. The first one is one proposed by the audience, by Matthew from the Washington Office on Latin America. And Matthew asks, before its signing, we saw that the so-called gender ideology resulted in changes in the final agreement, with several references to gender and LGBTI being removed. I was wondering how these changes affected your ability to shape arguments for inclusion in the special jurisdiction for peace. Are there other significant ways this myth continues to affect the implementation of the gender approach in the agreement? So that's one question to keep in mind. And I think another sort of closing question that can be kept in mind, particularly for our 2 panelists, is going forward, what do you see as sort of, and I think you've touched on this a little bit already, but what do you see as sort of the main opportunities and challenges that we should be keeping in mind in order to keep pushing these arguments, to keep pushing this strategy and to help sort of achieve justice for LGBT survivors, not just in Colombia, but also in the world. And so with that, if it's okay, we can start with Dr. O'Rourke. You are muted.
Sorry. Yeah, I'm mindful of time. So I mean, I did sort of try to dedicate my comments to this question of sort of what to do and sort of how to capture opportunities. I know that the WPS anniversaries come up quite a bit, and maybe just sort of in response to some of the things Kelly said about the sort of challenge and opportunity of the sexual violence focus. I mean, it's always been my sense that what happened simultaneously around WPS and sexual violence was simultaneously kind of a narrowing of the scope of the agenda, but a broadening of the potential victims. So once we moved away from a broader gender inclusive peace building agenda, it became actually much easier then to define, to identify, well, if we're talking about sexual violence and conflict, actually there's a range of victims here that are not only women and girls. And it became easier, I think, in that space to talk about male victims of violence and, well, to a lesser extent, I think, sexual minorities. And, but I do think what happened as well with that, whilst obviously there's things to be welcomed there in terms of sort of making male victimhood visible and making the victimhood of sexual minorities visible. What definitely happened though was the sort of evacuation of gender politics and a recognition of gender power dynamics that sort of structure all of that violence. And I think we shouldn't be in any way surprised by that, you know, particularly at the Security Council. So the thing to be mindful of, I think, really with the WPS agenda is never to concede the territory fully to the Security Council to define it, because it will be done in problematic ways. And actually, I looked in more detail at specifically the question of Colombia's engagement with the Security Council and things like how perpetrators of sexual violence are listed through the Security Council processes. And, you know, Colombia has been very interventionist there in terms of how non-state armed groups and state forces are included or not included in those listing processes. So there is not the autonomy that one would like, I think, in engaging those processes. So I think the key lesson really is to never to concede definition of WPS to the Security Council, because it will not be the definition that we look for. And that is why I do come back to this question of, you know, where are the opportunities elsewhere? So certainly the work that you're doing in engaging international criminal law with the ICC and elsewhere, you know, that is really where we may be able to open up the definitions that are then ultimately incorporated into Security Council language. So where there is sort of definitions of, you know, gender-based violence, you know, if that's defined more inclusively in international criminal law, that definition can be brought into the Security Council by that kind of backdoor, and likewise with human rights language, where it's done more inclusively. So, but it seems to me, I feel like I'm telling the people who already know this. You guys in Colombia have really set the agenda around this and have inspired us in how to do this work more creatively elsewhere. So my principal comment, I think, is just to encourage you to continue doing what you're doing. And I think, and again, I'm reflecting a lot on Kelly's point about the competition for resources that sometimes this the issue of LGBTQ inclusion can raise. It seems to me, again, that you're modeling a way to do that that is about bringing people along and building alliances and avoiding competition for resources. And I think it is always to be mindful that, and I suspect we're setting up for a battle on this at home at the moment, but it's to be mindful about sort of who it is you're making your claims against, right? You're claiming certain resources and recognition from the state. And you're not making those claims for recognition and resources from other marginalized groups. And it's always, I think, to keep that in mind as you move forward. So, thank you.
I'll just quickly, one point to add on what can be done. And I think Colombia is already doing this, but when I think of other contexts, particularly around transitional justice processes and those international institutions like ours that go in to assist, is to really try to help facilitate building those bridges with the small group of maybe activists or organizations that do exist for LGBTQ individuals, and to try to bring them to the table with women's rights groups, that often there is this divide, and using, I think, the work that you guys have produced to say, you know, that there's a lot more commonality here in what you ultimately want to achieve in society. As you can see in this argument that breaks down what the drivers of this type of violence are. And so I think that there's a lot of building of bridges that need to be done, and sometimes international organizations are sometimes a little more neutral or non-threatening to be able to create that space to bring those people together. So I think that's really important, is this inclusion in conversations, and not just as an add-on, but to try to build allies, much in the way you've done in Colombia.
And I think finally, Daniela can help respond, can help answer the question from the audience.
Well, thank you, Matthew, for your question. And of course, regarding the question I left maybe not very well answered about the pushbacks and the challenges said by Kelli. Of course, the gender ideology movement was a very important setback for the LGBT movement and the women's movement, who are very committed to pushing the agenda in the peace conversations to have a robust gender approach for the transitional justice and for all the other elements of the peace agreement that were also been targeted because at the very beginning, as you saw in the pictures, the table was all male composed, so it was a very manly peace building process, as all the other peace building processes in the world. And what the LGBT, but especially the feminist movement, and with this, I think it was especially in that moment in which this alliance emerged, because if it wasn't because of their work pushing for a gender agenda in the peace agreement, there wouldn't be any kind of resources for LGBT people to push for a specific agenda in the peace agreement. And then there was it was very sad to see that these conservative groups allied with the opposition to the peace agreement to say that our agreement had in its core our gender ideology platform to transform our more deeply beloved traditions on heterosexuality. And it was very sad because they actually gathered a lot of very disciplined voters who actually went to the polls voting against this this homosexual project of nation that the peace agreement brought, and they actually won using that strategy. But this only opened like a portal of opportunity for us. We constituted a platform called HIPAS, which is gender peace and gender, or gender on peace. I don't know, Lucia, you can correct me. But with this platform, what we did was to advocate for the renegotiation of the peace agreement to have a very robust gender approach. And actually what this helped us to do was to make it more operative, because as the professor Rurik stated at the beginning of her presentation, operationalizing gender categories is quite a challenge for us as feminists. So what we tried to do was maybe to take out, they took out a lot of LGBT references or gender references in the peace agreement, but at the core, what we try to do is to use the principle of equality and non-discrimination based on gender that is in every single human rights treaty, to understand that this was more like a more comprehensive approach than just the gender one. And using equality and non-discrimination principle was a very important asset then to advocate for the statutes that regulated the peace agreement, such as the special jurisdiction for peace statute. So what we saw at the very beginning as a challenge, as a setback, as a pushback, then became an opportunity to make this more operative and to use this as an important asset to overcome the structural challenges faced by LGBT people to access to justice. And let me just finish to say what is happening right now, because gender ideology hasn't gone. Gender ideology is still a very important mode for the public debate here in Colombia. And we have now a very conservative government, which is increasingly promoting an agenda that wants to set a pushback for the sexual and reproductive rights of women and LGBT people. And it's very curious how they are using, but not only that agenda, but also the peace agenda. This government wants to push it back. So it's very curious how they've been instrumentalizing the sexual violence committed against former members of the guerrilla, specifically the FARC, to try to overthrow the special jurisdiction for peace. Now, what they're trying to do is to reduce their scope, reduce their framework of action, and they are using sexual violence as a weapon to attack the jurisdiction. So that's very curious, because they were never interested in sexual violence before, and apparently they are only interested in sexual violence when committed by these rebel groups, but now when committed by members of the state, which is a very systemic violence that we want to talk. And this is I'm going to make some publicity here. This is something we discussed broadly in our report for the Truth Commission, which will be published very soon, and you will be invited to the launch of that report that was coordinated by my dear friend and colleague Lucia, and it's very it has a very important analysis she brought on the state's patterns of violence against LGBT people committed by armed forces and by paramilitary groups. So yes, I will leave it there. Thank you very much again.
Thank you so much, Daniela, Dr. O'Rourke, Ms. Muddell. I think that's a perfect place to sort of wrap things up. You know, I think what sort of the big message of everything is that, you know, this has been a fight every single step of the way. Women's groups and LGBT groups had to fight to, you know, get included in the peace agreement, because like Daniela said, it was a primarily masculine space when it started in 2012, and it wasn't until 2 years later that gender even like got on their radar, and it was precisely because of women's organizing. And then after we were included, it's now been a struggle to sort of make sure that those, you know, that symbolic recognition is actually becomes a reality, and that we're not just left with a yawning implementation gap, you know, which is something that, you know, we've been warning about, and also that, for example, the Kroc Institute has been warning about as well. You know, and I think that the reason that we've come so far and been able to achieve, you know, to actually keep pushing the envelope and setting international standards in terms of women's and LGBT inclusion and peace building is because we have incredible allies like you guys. Who are willing to take the time to, you know, fight with us, discuss our ideas, make them better, amplify them, incorporate them into your own work, and also, you know, give us feedback, tell us what you think about what it is that we're doing here. And so I think we're incredibly grateful and flattered that all of you took the time to be here today. Myriam Roccatello, Catherine O'Rourke, Kelli Muddel, and Victor, even though Victor Madrigal-Borloz, although he's no longer with us, but I'm still gonna give him a shout out. We're very, very, very thankful that you guys were here and that you've decided to help support us through this process. At the end of the day, we hope that this is going to help achieve justice for the people that we work with and who are really at the heart and soul of this work, right? This is not about us, this is about them who have never had a positive relationship with the Colombian state, and that this is sort of a historic opportunity to help reframe, sort of reconfigure that relationship and sort of repair the harms that were done after so many years of neglect. So again, thank you so much to all of you, and thank you so much to our audience who has stayed throughout what was a relatively long but rich event, I believe, with a great and lively discussion. Thank you so much, you guys, for sticking with us, for being here. We hope that you get a chance to read the book. Like I said earlier, it is on Colombia Diversa's website, www.colombiadiversa.org, both in Spanish and in English. And we look forward to hearing all of your thoughts about these thoughts. And like Daniela said, we will also have a piece, the report for the Truth Commission, coming out soon. So thank you guys once again, and we look forward to continue working with you in the future. Bye, everyone.
Thank you very much.
Bye. Congratulations again.
Thank you. Take care. Bye-bye.
Bye.